Hi everybody, welcome back. Today we're going to talk about business organizations. This is part one of a two-part series. In the first part, we're going to talk about some simpler business structures. The whole second part of the series is going to deal with corporations, which is much more complex. There's a lot more information. But for this particular slideshow, we're going to look at sole proprietorships, partnerships, limited liability companies, and joint ventures. All right, so let's get started. First of all, if you're working for a law firm that handles business law or corporate law, as sometimes they call it, you're going to be dealing a lot with how businesses operate. Businesses that are already in existence, you're going to be dealing with, their interactions, their transactions with other people. But you're also going to be dealing with perhaps the creation of new businesses and the end of businesses, which is called the dissolution. So it covers all aspects, but really from birth till death of these corporations, these sole proprietorships, these partnerships. So there's a lot involved. So the purpose of these slideshows is to get you familiar with how these business entities are set up. And so let's get started. Okay, sole proprietorship. This is very common. It's the simplest, but it also carries with it a lot of disadvantages. But it also has a lot of advantages too. So for example, as an attorney, I have been a sole proprietor. I've also been in a situation where I've been in a partnership. Sole proprietorship is risky, and I'm going to start off with the disadvantages because if somebody were to sue my business, they are suing me individually because I share my identity with my business. So that's the major disadvantage. So if somebody ever asks you, oh, well, what's the downfall of having a sole proprietorship? You go, wow, well, you have liability, and they can come after your personal assets like your house, your bank account, your cars, anything that you own could ultimately be at risk if you're in a sole proprietorship situation and somebody decides to pursue a lawsuit against you. Now, the advantages, oh my goodness, you can make your own schedule. It's very flexible. You make all the decisions because you are the manager. The financial structure, hey, guess what? You and the business, you share an identity. So you are it. So, for tax purposes, you want to make sure you keep your business account separate from your business account and your personal account separate, but still, it has so many great advantages. And you can use your personal Social Security number as your business Social Security number. So, it's so simple to set up. And in most states, you'll just require a simple business registration to say that you're allowed to do business, and then you're off and running. But let's go down this list because each one of these is going to have this same type of a list. So the advantages, obviously, I talked about are flexibility. The owner can apply their business losses against their personal income taxes. So if I lose money in my business, I can apply that to my personal income taxes as deductions. So it might lower my taxes. But that disadvantage is that I have unlimited personal liability. For financial structure, I shared the business. My identity and I have the same, the business and I have the same identity. I, as a manager, would have complete control. Liability, of course, is unlimited personal liability for the owner. Now, when the sole proprietorship, when it comes to an end, if I die, my business dies. So the duration is limited by the life of the owner, and I can just end it at any time. I can just say, I don't want to do this anymore, and I can dissolve it. I don't have to worry about anybody else because it's just me, okay? So now what if I wanted to take on another person? So me and one other person. And we decide to go into this same pursuit, and we want to make some money doing it. So that's going to be called a general partnership. Now, I don't have to get anything from the state to start a partnership. Same thing with the sole proprietorship. I really didn't need to get anything from the state, just a business registration, just basically says I'm a business. Same thing with the general partnership. I don't need any special permission. And everything that I do with my partner is actually governed by what's called the Uniform Partnership Act. It's called the UPA. So now when we form our business, there doesn't have to be a written agreement. However, it is smart to have a written agreement. But if we don't have one, the Uniform Partnership Act tells us what it gives us that information. It says how we should operate. Now, if we're going to have our business for more than 1 year, the statute of frauds basically says that we should have that agreement in writing. Okay, so make sure that if you're in a partnership and you plan on being in it for long term, then you need to make sure that you do have something in writing. But if you don't have something in writing, the Uniform Partnership Act is going to fill in all of those blanks. Now, the financial structure, a lot of people get confused about partnerships. They make the assumption that everything is 50-50, and that is not true. Now, obviously, you can have things be 50-50. That's up to you. But let's pretend I'm in a business with you, and you put in 70% of the money to get the business started, and I only put in 30. So you've put in 70% of the capital, and I've only put in 30. So whenever we split the profits, you should get 70% of the profits, right? And I should only get 30%. And that's how it can be set up. You and I don't have a 50-50 relationship because we didn't start off at the same level, did we? So you have to understand that it doesn't always have to be 50-50. Please understand that, because a lot of students miss questions about partnerships because they think it's 50-50. And this money or assets can be put in. Maybe you put in 70%, and my 30 was in the form of I gave the office space. Maybe I owned an apartment building or an office building, and I donated that office space to us, and I didn't actually give money to the business. I contributed real estate, and we decided that was worth 30% of the total business. See what I'm saying? So the contribution can be in a form of many different ways. If we don't specifically state how much money each of us put in at the beginning, it is presumed that it is 50-50 and all the profits will be divided equally. That's why it's really important to get it in writing. Now, you as somebody who put in 70%, it would be really important for you to make sure that we got this in writing so that you would get 70% of the profits. Okay? How is it managed? Well, the law presumes that you and me, we're going to devote our full time and attention to operating this business. We are not going to get paid. And that we'll each have equal management authority. So we have to agree on things for things to move forward. If we disagree, it's not happening, right? Because we each have one vote. However, if a different structure is desired, then we must state it in writing in the partnership agreement. We can also take on somebody who's called a silent partner, and this is someone who assumes all the benefits and the burdens of the partner status except in the area of management decisions. So a silent partner would be somebody that maybe contributed money or funds, but they have no say-so in how the business is run, and that's why they're considered silent, because they don't get to speak to any of the management decisions. They're just there as a money person, and they also get part of the profits. Okay, so this might be somebody that gave us money to start the business, and they say, well, in exchange, I just want like 10% of the profits or whatever. That person is considered a silent partner whenever they have nothing to do with management decisions. Now, if they start to make some management decisions or get more involved in the business, then they lose their silent partner status. For liability purposes, if somebody comes in and sues you and me, we are still personally liable for our partnership debts, just like the sole proprietorship. Unfortunately, they can come after your house, your car, my car, until they get the money that they need to compensate them for whatever their loss was and the reason for suing us. Now, when we're ready to let this partnership go, for whatever reason, if one of us decides we don't want to participate in this partnership anymore, the partnership is dissolved and the remaining partners may elect to continue the business. So, if you decide to get out, I can continue the business as a sole proprietor. If there was another partner, the two of us could continue. Now, there's something that's also called a limited partnership. What I described to you on the previous slide was called a general partnership. A limited partnership is whenever two or more people get together. In this case, we form our partnership under the principles and laws that were provided by statute. You see, a general partnership And a sole proprietorship, we didn't really have to follow any state rules and laws except maybe getting a business registration. But a limited partnership provides certain protections to some of the partners. So this is much more, once it starts providing protection, that's when you have to really start abiding by and complying with state laws. And you'll see what protection is available to these folks in a minute. Okay, a limited partnership is where you have general partners, which I've already described on the previous slide, but there might be one or more what are called limited partners. Okay, and now here's how it works. Okay, they would form the partnership under what's called the Uniform Limited Partnership Act, which is the ULPA. And now that has been revised, and it's called the RULPA, which is the Revised Uniform Limited Partnership Act. That has been adopted in the majority of states, and that is what's going to be asked of you in your certification exam. And they have to use the words limited partner in the firm name. So it's LP, limited partner. So when you see somebody's name of a company, I'm sure you see those letters that come after it. If you see LP, it means that it's a limited partnership. So here's how it's structured. Okay, so you've got your general partners. We already know in the last scenario, you and me, it was you 70, me 30. We can bring in a limited partner, so maybe it's you 60, me 30, limited partner 10. Okay, and they can contribute their money just like anybody else in a partnership. So under the Revised Uniform Limited Partnership Act, this limited partner could actually give us services, and that could be counted as their 10%. They could provide delivery services for us or something, and that counts as their 10% contribution. Now, under the old Uniform Limited Partnership Act, they couldn't have done that, but the Revised Uniform Limited Partnership Act has opened that up to them. Profits and losses are allocated among the partners according to the agreement. So in our scenario that I'm talking about, you would get 60% of the profits, I would get 30, and our limited partner would get 10. The RULPA provides that if profits and losses are not outlined in the agreement, that they are allocated on the basis of contributions made by each partner. Same thing I just said. Okay, so either we put it in the agreement. If we don't put it in the agreement, the RULPA says that that's how we're going to do it. In the agreement, we may decide, let's just split it all evenly and equally. Maybe we're all, family, and we just want to, even though some of us didn't contribute as much, we want to split it in thirds, whatever. Okay, we could have done that in the written agreement. If we don't, it depends on each person's contribution. Okay, how is it managed? Now, this is where we get that limited partner. This is what makes it different from a general partnership, because so far you're like, what is limited about it? Okay, for management, limited partners may not participate in the management or control of the business. Remember, silent partners couldn't do that either? Well, limited partners cannot participate in the management. General partners only in a limited partnership relationship. General partners are the only ones that can manage the business. In exchange for that, okay, the general partners, you and me, we're the general partners in my scenario, right? We still can lose our house and our car and our bank account if we get sued. They're going to come after not just the business, but you and me personally. The limited partner's only liable to the extent of their investment. So our limited partner, who only put in 10%, can only be sued up to that 10% of their contribution. Okay, that's it. Their personal assets are protected from liability. If a limited partner starts to manage and starts to act like you and me, then they lose their limited partner status. Now, they are protected by state law. That's why this is the first one that we've talked about where state law kicks in and says you can't go after personal assets. Now, why on earth would you and me want a limited partner? Okay, when we are going to incur all this personal liability potentially. Well, maybe you and me didn't have enough money and we needed just 10% more to get started. And the only way we could get that money is if the person said, look, I don't want any liability. If you guys get sued, I don't want to be a part of it. So the only way we could get this person to give us that extra 10% that we needed was to say, okay, well, we'll set you up as a limited partner. And that way you're protected and the only thing you could lose is what you put in. Does that make sense to everybody? That's the benefit of having the limited partnership and having a limited partner. Now, if we want to end this limited partnership relationship, we can dissolve it by agreement of the parties. If one of the general partners leaves, then it dissolves. Okay? Now, how do we distribute our stuff when somebody leaves? Well, the Uniform Limited Partnership Act, the one that was before it was revised, says that limited partners get their take first. So they get their 10% back first, and then whatever is left over, then the general partners have to fight over. That's basically what the ULPA said. The revised Uniform Limited Partnership Act, which is the most recent one, it says limited and general partners are the same. So basically, whatever we have left, in my scenario, you're going to get 60% of what's left. I'm going to get 30, and our limited partner is going to get 10. So if that's less than his original 10% contribution, oh well, so be it. Under the old laws, he would have gotten his full 10% back, and then you would have gotten 60% of what was left, and I would have gotten 30% of what was left. So, but they've changed it now, so we're all treated the same whenever it dissolves. So that's limited partnership. It's getting a little bit more complicated, right? It's not so easy as it was with the sole proprietorship and the general partnerships. Okay, limited liability company. This one so far is providing the most protection to the people who have formed this business. This is definitely something that was created by statute, and it's designed to protect people who are forming a business. So this is considered a hybrid form of business ownership. It offers the limited liability of a corporation, but it allows what's called the income pass-through of a partnership for tax purposes. So LLCs, limited liability corporations, the people who start them, they can, their tax returns can be done just like they would if they were in a partnership or a sole proprietorship. Okay, so that's good, but it also protects them it protects them from liability. So this is really great, right? They just have to comply with state statute. Okay, so for the formation, one or more persons may create an LLC by filling out a certificate or by filing a certificate of organization with the state, usually with the Secretary of State. And you don't have partners, you have what are called members. So it's just a definition of, it's just terms. So people who are involved in the formation of an LLC are called members. The members may manage or may assign management tasks to somebody named who they call a manager. It can be a member, but it doesn't have to be. So if you and me start a limited liability company, we can hire a manager to run our business. We can just kind of sit back and let the manager do their thing. Now, I know financial structure is blank on this slide. However, it's set up just like the other ones. It's based on contribution. Okay, so you can see under liability, the liability of each member is limited to his or her investment, unless the specific liability results from his or her personal conduct, like they commit malpractice or something. So if you put in 60% and I put in 40%, our liability is limited to the investment that we put in, our personal assets, your house, your checking account, your car. It's all safe. Mine too. Okay. But they can come after us for up to that 60 or 40 that we put in. Unless, like, for example, you and me, you commit some kind of personal misconduct and the liability is the result of you doing something, like you committed some kind of malpractice, then now your personal assets may be attached because you did something that was a personal misconduct. Now, when we want to end this limited liability company, it's not like a partnership where if one of us dies, the partnership dies. That doesn't happen that way. We have to actually dissolve it legally through the state because we formed it through the state. So we have to legally dissolve it. And actually, I can continue the LLC even though you're gone. Okay? And it can continue forever, even if you pass away. I just kind of absorb your part of the business. Okay, so that's limited liability company, and I apologize that financial structure is blank on this slide, but it is just it's contribution. We can put in as much or as little as we want to continue to form it. Now, a joint venture is a one-time thing. Most businesses that we've talked about at this point, you expect them to go on for a long time, and they could be perpetual, meaning forever. But a joint venture involves the combining of efforts by two or more persons for one transaction or for one event only. So the example is, let's say you and I are working together. We're going to put on a concert in Charleston, West Virginia. Okay, so we get the location, we get the entertainer, and you and me, our whole goal is to make this concert happen. Now, after the concert happens, you and me, we're done. Okay, so this is called a joint venture. It looks like a partnership because you and me are in this together, and we probably should have a written agreement, although it's not required. It's different from a partnership in that we don't contemplate that our relationship is going to continue forever. Okay, it's just for this one thing. Once it occurs, our joint venture dissolves on its own. Okay, so it's pretty simple. It sounds kind of fancy. It's a joint venture, but it's really just two or more people getting together to do something to accomplish a goal. Once the goal is accomplished, it's over. Well, it's been fun. Again, if you have, as always, if you have any questions, reach out, contact me, contact your instructor. Otherwise, have a good day.